Sumodhee and Keramuth and the state of Mauritius.
Please, Your Lordship, I appear together with my friends Uzia, Valaiden and Malek for the appellant in the first case. My friend Hussein Bacchus and Ms. Mia Saib appears for the appellant in the second case, and Mr. Hussein Bacchus appears for the appellant in the third case and instructed by Mr. Bahimia. For the respondents in all the three appeals, it's my friend the learned DPP who appears in person, Mr. Boulel, Senior Counsel, together with Mrs. Sanasi and Mr. Arnold. My Lords, during the course of my address, I shall be addressing your Lordships in respect of all three appeals, since more or less they cover the same ground. But my friend Hussein Bacchus, if the need arises, will address your Lordships in response to the written case of the respondents. My noble Lordships, this appeal arises out of a tragic set of facts. On 23rd May 1999, between 6 and 7 p.m., a group of arsonists set fire to a gambling house known as L'Amical. In the fire that ensued, 7 people lost their lives. That the crime was heinous goes without saying, my lords. And it aroused anger, distress in the public, marches were held, speeches were made, and the public required swift retribution. It is against that loaded background that the appellants were tried and convicted. One of the issues that arose was that in the course of his summing up, the judge firmly guided the jury to a conviction by the choice of language he used, the tone he used, and the directions he made, and ground 25 of the original ground of appeal read as follows, my lords. The learned the reference would be in volume 2, my lord, at page 484, my lord.
484?
Yes, my lord. I'm sorry, 454, my lord. 454.
Is that the same electronically, do you know?
Yes, it would be the same, my lord. It would be the second paragraph at page 454, my lords.
I think we'll have to start up again, Jonathan. Coming up.
I'm afraid, yes. Need to start again.
Are you with me, my lord?
No, I'm afraid it wasn't. It was frozen, so we need just to start again.
454, my lord.
Yes, thank you.
It's the second paragraph under the paragraph 25. That's ground 25, my lord. If your lordship will go to the hard copy, page 454, it should be the same, my lord.
Well, it's all to do with the judge's directions, his language and inflammatory tone.
Yes, my lord.
And you say this can be gathered from the digital recording.
Precisely, my lord.
And that's in relation, is it, to the evidence of Thupse?
Sorry, my lord.
Is it confined to the summing up in relation to the evidence of Thupse?
Yes.
It is. Okay.
Yes.
Of course, Mr. Ramburn, let's not forget that when Mr. Buckery began his submissions to the Court of Criminal Appeal, he disowned the word inflammatory.
But he disowned it, probably, my lord, not having had the opportunity to hear it.
Yes.
The difference.
Very well.
So, my lords, after the grounds were settled and filed, fresh counsel had been retained to appear in the matter, as your lordships would have gathered, and in order for them to properly prepare and to argue that point, in fact, 2 letters were sent, my lords, to the Supreme Court on the 30th of September and the 8th of October. I will not take your lordships to that because, in effect, what he's saying is to, first of all, give us access to the audio recording, and secondly, for the court to hear the audio recording of the summing up when we are going to hear the appeal.
Yes,
In
give
effect,
us a reference there.
This is, in effect, what those 2 letters are. And
Give us the page references for it.
that would be page 486 and page 487, my lords.
Thank you.
And you will see at page 488 of the brief, my lord, on the 11th of October 2004, the respondent indicated that they would be objecting to any such motion.
Yeah.
Then the matter was argued, my lord, and the Court of Criminal Appeal, in its judgment dated 27th of October 2004, which is to be found at page 509 to 515 of volume 2,
Rejected it, yes.
came to the conclusion inter alia that there was no requirement in our law for a copy of the recording of the summing up to be made available to the appellants, and in all the 3 cases, and secondly, they even refused to consider hearing the tape recording of the summing up on the authorities of Wood and Nelson.
They certainly refused to hear it. Can you just it's my fault. I thought I had it, but I've lost it. Which page is it at which they say that you weren't entitled to a copy?
Yes, my lord. If you go to page 513, my lord, of volume 2.
Yep.
That would be the 2nd paragraph, which starts, "We agree."
No requirement. Yes, thank you very much.
And then, well, I'll come back to that later, in the next paragraph saying exactly the contrary. That there is a law, but they won't use their discretion. But I'll come back to that later, my lord. So, my lord, upon the refusal of the Court of Appeal to allow the audio recording of the summing up, instructions of the appellants obviously could not be pursued with, because the whole ground rested on the listening of the audio recording. So, in effect, it fell to the side without being heard. So, it is that failure, my lord, which is the crux of the appeal before you today. And I believe, my lord, the issue is whether it was necessary and essential for the Court of Appeal to allow that motion in order for the appellants to pursue their appeal to the fullest and ensure their right to a fair hearing.
It's not just a question of whether it was necessary and essential, it's a question whether your clients had a right.
Yes, my lord.
Yes.
In fact, this raises...
Right, there are 2 questions. The first question is whether your clients had a right to see or hear, have a copy of the recording itself. And the second question is whether it was necessary and essential for the court to listen to it or any part of it itself. They're 2 separate questions, aren't they?
Sure.
And, if you establish the first, the second doesn't necessarily follow.
My lord, I believe as your lordships, I had it in another way, that this raises 3 fundamental questions, my lord. First of all, is there a requirement in the law? Secondly, if the answer to this is, has it been breached? And thirdly, what is the remedy for such breaches? That is how I'm going to address your lordships. So, my lord, I believe that the right ought to be found in this matter, both in the Constitution and under the statute. I will refer your lordships first to tab 2 of the bundle of authorities, which is our Constitution. My Lord, if you come to section 10.1, where any person is charged with a criminal offence, then unless the charge is withdrawn, the case shall be afforded a fair hearing within a reasonable time and independent and impartial court established. My Lord, it will be my submission that the constitutional concept of a fair hearing already encompasses a requirement of allowing a recording of the summing up, which is available to be communicated when requested, and extends to the court listening to it as and when necessary, as my Lord said. By the use of the word shall and fair in section 10.1, in effect, I believe, my Lords, place the court under a duty to ensure fairness, because fairness is the underpin of that section. And this is my first ground that for the proposition that the appellant had a right under 10.1 itself for the disclosure. Fairness. Then, in addition to that, my Lord, I will say that the second instance under the Constitution where such a right do exist is under section 10.3 of the Constitution. And probably this is more specific. And 10.1 is the generality, but 10.3 is the specific. And I will take the pain to read it for
Well, you needn't read it. We can look at it ourselves. This is the one you've relied on in your case, isn't it?
Yes, my Lord.
I suppose you rely in particular on the word any.
Precisely, my Lord.
Any record of
Any
proceedings.
record of the proceedings made by or on behalf of the court.
Yes.
Any.
Right, well, we've got the point.
So any in the circumstances cannot be given that narrow interpretation, my Lord. And if I may add, my Lord, I believe my submissions is reinforced by section 1773, because we must remember, my Lord, when the Constitution was drafted and enacted, there was no digital recording in place. And so in 1999,
Is the Constitution 1960?
68, my Lord.
68. Thank you.
So, sorry, where do we go now?
To tab 16, my Lord. Section
Courts Act, yes.
Yes, Courts Act
94.
1773, which is to be found at page 1321.
Yes.
So last amended 92 and 99,
Yes, my Lord.
right?
The page number was 1321.
21.
1321, my Lord.
Thank you.
And if you see, in this subsection, we see the manner in which a recording of evidence can be done by at the Supreme Court.
This is alternative to the
Yes, the first is by the judge, then second, 2A is, B is...
So it may be recorded by tape or other technological means, and the judge may give... Yes, I see. Right?
Right. So this becomes the record.
Well, yes, I think the director is going to ask us to turn a page back and look at section 24.
Yes, my Lord.
Shorthand notes. In every case, civil or criminal, the registrar shall ensure shorthand notes are taken, and a transcript of such notes shall be made if the presiding judge so directs, and such transcript shall, for all purposes, be deemed prima facie to be the official record of such proceedings. And I believe the director is going to submit that we've got to read the word record in section 10.3 of the Constitution together with section 24, and so he's going to be arguing that it's the transcript that is the record for that purpose.
My Lord, what I would answer to that, my Lord, is in this day and age where technology has made so much advance, when you have the primary source available, why should you not be allowed to have it?
Well, these days, in a criminal trial in the Supreme Court, is there a shorthand writer?
As far as I'm aware, my lord, there is only a registrar who switches on
Who has a
the
tape
tape recording,
presses the button.
presses the button, and then ends the button, do the timeline, and then it's sent to the transcriber for him to put it in the record.
So the transcript derives from, you say,
Of the audio recording.
right.
In any event, I dare say you would want to argue that while the provision referred to by my Lord, Lord Wilson, deals with the record of the proceedings, Section 10, subsection 3 of the Constitution deals with any record
proceedings.
of the proceedings. And by any standard, the fact that there is a recording of the proceedings must come within the embrace of the expression, any record of the proceedings. It looks as if we're getting a record
Yes,
of these proceedings.
somebody is making, obviously. Right. I think it is to do with the fact that we're set up, if necessary, to listen to.
If necessary, my lord, I will.
Right, well, carry on. There does seem to be a slight disconformity between sections 24 of the Courts Act and section 177. Well, I say disconformity. Section 24, they're both amended, so we don't know what they look like in their original form. They may have got out of synchronization.
Yeah.
Because certainly section 177.3 seems to
My lord,
contemplate things which are not covered in section 24.
I believe what may have happened, my lord, if I may.
Yes.
Section 24 was amended in 1992, and 1773 came in 1999. But I think there is a lapsus there where they omitted to make the completion for Section 24. This is the only explanation I can give you why it is not in sync.
Your understanding is it that section 177.3 was added when?
In 1999, my lord.
Can we see that somewhere? Or perhaps it's not in dispute.
I think, my lord, it is under 1321. You'll see Act 28 of 1999.
Well, I can see that, but
Yes,
it
but it
doesn't
doesn't-
follow that it's added subsection 3.
Okay.
It may have done.
Yes, I know, my lord. It is my fault. I assume that your lordships would, and there would be no dispute on that.
Well, there probably isn't. Anyway, that at least is your assertion, that it was
Yes.
added in 1999. Thank you.
Yes, my lord.
The other thing to note, I think, is that Section 24 says the transcript shall, for all purposes, be deemed prima facie to be the official record of such proceedings, whatever that may mean.
My lord, I beg to apologize to intervene, but we have a copy, if your lordship may wish to have a look.
Of the original.
Of the amendment to section 177.
Is it 1999?
Yes.
Yes. Well,
Well, it was added in 1999,
Yes.
subsection 3. Okay, that's helpful. And that is, what about section 177.1 and 2? Was that there before?
I think that was there before, my lord.
Yes, well, that explains why you get the words "and proceedings" in subsection 3, which you don't get in 1 and 2.
One looks as if it's of some antiquity, doesn't it?
Yeah. Right, thank you very much.
My further submissions, my lord, so that would be, I think it is taken care under section 10.3, my lord. That would be my proposition to your lordship.
When you say taken care under 10.3, obviously
That is, the legal right is under the Constitution.
Constitution can't be affected by these statutes.
Precisely, my lord.
But you say, if you look at the statutes, you find that it is reflected in 1773.
Yes, my lord.
Or at least the ground is
The
laid.
ground is there, yes, my lord.
Laid for it, yeah.
My further submissions, my lord, is that there are also statutory instruments which cover same, and they are to be found in the Criminal Appeal Act as well as the Criminal Appeal Rules. And I think before we embark on any analysis of those sections under the Criminal Court of Appeal Act, my lord, it is apposite now to see the judgment itself, the issue which I drew the attention. It seems there is a contradiction in the manner in which the Court of Appeal approached the problem. And if we go back to page 513,
Well, we haven't looked at section 3.7 of the Act yet, have we? So where do we find that?
no, my lord, it's, in fact, I think it's a mistake there. It should be section 3.6 instead of 3.7.
Well, where is it?
3.7 is...
So where's 3.6 then?
It's tab 3, my lord. Page 1187 to 1199.
1188?
1188, my lord, yes.
Sorry.
It cannot be 7, it must be 6, my lord. 3.6. There in the judgment, reference is made to 3.7, but I believe that is a mistake. It should be 3.6.
Have power to determine any question necessary.
Yes.
Right.
Right.
Right. So, if we read those two passages, my lord, so on the one hand, what the Criminal Court of Appeal is saying, we agree consequently with the submission of the learned counsel for the respondent in the second and third appeals that there is no requirement in our law for a copy of the recording of the summing up of the presiding judge to be made available to the two appellants in the second case and to the appellant in the third case. And the very next passage, having said that, however, we hasten to add...
No, they're not contradictory, though, are they? What they're saying is there's no right, but the court has a power. That's not contradictory. I mean, it may be that you find that it's a bit odd to try and find the power in Section 3, subsection 6.
Well, my lord, may I pose here, what gives them the power? The power is from legislative source, from the statutes.
Yes. All they're saying is, Mr. Ramchani, that we're not obliged to listen to it.
Oh, yes.
We've got the power to do it if necessary. Your case, as I understand it, is that the defendant, the appellant, can't be expected to know whether to ask them or not unless he's first seen a copy.
Yeah.
Is that it?
Yeah.
So there's no right for them to have it, that's what they're saying, but we have a power, but then you run into the problem my lord has identified.
But
so
my issue here, my lord, is when they say that there is no right, but they tell you there's no requirement in our law. It's not a question of no right. There's no requirement in our law.
yes.
Well, it's a question of semantic, my lord. But at the end of the day, Section 3.6 gives you that power. Therefore, you must ask it, but subject to condition.
No. They say Section 3.6 gives the court the power. I think you're making a bit much of any problems under these paragraphs. Your case seems to me quite simple. I mean, you say you've pointed us to provisions which actually give your client or gave your client a right.
Fair enough, my lord. Fair enough, my lord. But
now, you say so therefore we're not concerned about court's powers at this stage.
Suffice it to say, my lord.
The court undoubtedly, you may have a right to see it, but do you accept that the court doesn't have an obligation to listen to it?
Of course, it doesn't have an obligation to listen to it, my lord.
Assuming we were with you on the first point, you will have at some point to demonstrate why the Court of Appeal
and I believe
should have listened to it.
Yes.
Or rather, why we should listen to it.
Yes, my lord. And I believe if we go to section 11 at page 1193,
yes,
I think this is where the court ought to have listened to it.
Yeah.
I suppose what you might argue is that if it is necessary for the purpose of doing justice, that the appellant should have access to the tape, if that can be demonstrated, then although the court has power to do it, it's obliged in the interest of justice to exercise that power.
And I believe, my lord, section 11A makes that very clear.
Right.
11.8.
Yes, my lord, at page 1193.
So even if you don't have a right to see it, in the circumstances of this case, you would say?
Yep. See, for the purpose of the court may, if it thinks it necessary or expedient in the interest of justice, order the production of any document, exhibit, or other thing connected with the proceedings.
Nobody's ever suggested that the court hasn't got power to order it.
Yes.
The question that it was addressing was whether it was required to order it.
The last part, madam, where the production appears necessary for the determination of the case.
Yes, yes, yes.
So in this case, my lord, you have read the ground of appeal 25. Wasn't it necessary to be able to dispose of that ground of appeal properly and fully?
On your case, you don't get that far. On your case, you say, we have a right. We must be given, on payment of the proper fee, a copy of the recording to listen to it.
Yes.
And so this business about the court may, discretion, order the production if necessary or expedient, you say you don't reach that.
No, I don't.
But then, probably in the alternative, you say, if you're wrong about there being a right, then you do reach it.
Yes.
Now, if you're correct, I better say, hadn't I? If you're correct about the right in the appellant to see a copy of the tape, the next question is in what circumstances must the court, in order to do justice, hear it? Yes?
Yes, my lord.
Right. Now, in Mauritius, does an appellant who wants to launch an appeal against his conviction require leave?
To the criminal court of appeal?
Yes.
No, my lord.
Quite. So it follows, does it, that simply by drafting a document without any further filter or any further requirement to demonstrate that the point is arguable,
Yes.
he can, as it were, put on the table any issue that he chooses.
Indeed, my lord.
Do you say that simply by asserting that there was an inappropriate tone used by the judge, simply by asserting that, it follows that the court is obliged to spend however long it takes examining the tape to find out whether it's right or not?
My lord, I believe that at the time when this ground was drafted, counsel was the counsel who was appearing in the case, and advisedly it would have put the ground of appeal. I do not believe counsel
I'm
would
right in
just...
saying it was drafted by the attorney, but
Yes, by the attorney, probably.
But still, what's the answer to my question?
The answer to your question, my lord, is if your lordship is asking me whether we should have some form of evidential basis to, in order to prosecute that appeal, that ground, then, my lord, how does one do it without listening to the tape?
Yes. Well, of course, if you had a right to the tape, then you would necessarily be able to point to the parts of the tape which are critical. And in fact, I mean, assuming you had a right, we are the first court to be in that position.
Yes.
Yeah.
But I mean, assuming you have the right, assuming you have the tape in your hand and you've listened to it, can you demand of the Court of Appeal that they listen to the tape without persuading them that there is substance in your complaint? That's the question I think Lord Hughes is trying to put to you, or is putting to you.
My lord, I believe that it would take some persuasion first, because it is not for the court just to embark and to listen to the audio tape.
So you accept that you need to persuade the court with some reason?
You will need to at some point in time.
Is there this safeguard or not, Mr. Ramchan? Is it recognised as part of the law in Mauritius that counsel is not entitled to advance before the Court of Appeal a ground which is not properly arguable? Because in England, it's very clearly part of counsel's duty, and if counsel would be in serious trouble for simply listing a whole string of grounds if they're not arguable. Of course, you need leave in this country, so there's a filter.
Precisely, my lord.
But it's even more important if there isn't a filter. Now, does that rule apply in Mauritius or not?
No, my lord, it
I
doesn't
thought you
apply.
might say that.
It doesn't apply. But one would have expected, my lord, as most of our barristers would have the same or similar code of ethics.
Similar standards.
And similar standards would be to follow the same procedure and same standard.
Well, wait a minute. I mean, that's a bit contradictory. If it's understood as an ethical standard, then why isn't the position the same as Lord Hughes has outlined? Would you say in practice, nobody ever takes any disciplinary steps against a barrister or advocate for raising rotten points in court in Mauritius.
No.
No.
Well,
But not that I know of.
it's a court which is under a good deal of pressure, isn't it?
My lord.
Well, there we are.
Right. Well, I mean, the position is that if we're with you on the right to see, to have a listen to the tape, to have a copy of it on the face of it, then the question, I think, arises whether you can say that there is some reason why a court, perhaps us, should listen to any parts, since you've done so and ought to be able to point to the parts which are objectionable. And you have, to some degree, sought to do that. We'd need to look at your case. Even if there isn't a right, you have in fact listened to the tape, so you ought to be very well placed, again, to do the same exercise.
Yes.
And we probably, well, perhaps we still have to consider whether you put sufficient before the judge without seeing the tape to require the court, in the interests of justice, to produce the tape.
In this case, the difficulty would have arose at that time for fresh counsel to be able to put anything before their lordship, yes, because he had no access to the tape at all, and he wasn't the counsel there. So what would one would have expected him to do?
Well, he could have put in an affidavit from counsel who was there or anybody else who was there, but apart from that, I take the point.
Normally, in any event, you say it's very important to keep the sequence clear here. The first stage is that you're entitled to have the tape.
Yes.
Once you get the tape, you accept that it is necessary for you to put before the court material which will satisfy the court or convince the court or stimulate the court into a decision that it is necessary for the court to hear it. Yeah. You didn't get past first base,
yes,
because you didn't get access to
it. The question didn't even arise for the appellant to get to that.
Well, perhaps we can move to the second stage. And I mean, why do you say that the court, if they had given it, or this board should now listen to the tape or sections of the tape?
My lord, let me put it this way. I see time has passed now, my lord. We are nearly 17 years down the road. This trial took place, and those persons were convicted to life imprisonment in 2000. The appeal was heard in 2004 and in 5. And obviously, just to complete the picture, they have been in 2015 by the Prerogative Commission of Mercy, have the sentence reduced to 18 years.
Released on the 17th of March 2019.
Yes, and there again, I fail to understand 119. When it's in 2000 they were convicted, 18 years should be in 2018, but that is another matter altogether. But by the time now, my lord, if we were to listen to the tape, my lord, and I speak advisedly under your corrections, my lord, what is going to happen next? Are we going to decide on the tape, of the summing up on those parts in abstracto, because the whole proceedings is not before your lordship? Can you?
Well, we've dealt with a very large number of other complaints, and you haven't got permission to appeal on them.
I know.
And we are, I'm afraid, therefore confined to considering whether the summing up was, in this respect, fair.
Yes, but before we get to that, my lord, then my point, my lord, is what is the effect under the Constitution of not disclosing in the first place the tape to the appellants? Isn't that a breach of his right to a fair hearing? That is my first point, my
So
lord.
the failure to disclose, are you asking us to say that it follows from that? Wait a minute, hang on.
Yes, my lord.
Are you asking us to say that it follows from that without more, the simple refusal to provide a copy until very recently? Are you saying it follows from that without more that the conviction is unsafe?
My lord, presumption of innocence runs according to section 10.2 up till now.
Is the answer yes or no?
My lord, the safety of the conviction is still questionable if we listen to the summing up and then decide that there was inflammatory matters.
Sorry, look, Mr. Ramchand, you really must answer the question. Are you asking us to say that if you are correct, that he was entitled to a copy of the tape ages ago,
Yes.
didn't get one, it follows from that by itself that the conviction should be quashed?
Well, my lord, yes, I would.
Go on. That's what
I
I
would.
thought. That's what
I
I
would, to the extent that, may I just also,
But you've got to introduce the proviso then, don't you?
Yes.
well, the proviso, my lord, would the proviso be in compliant to section 10.1, right to a fair hearing?
But you can have all sorts of, I'm afraid, unfairnesses in the course of even criminal proceedings, including undue delay, for example. But that doesn't mean that you have a right to be acquitted or released.
Yes, certainly, my lord.
The court has to consider the position.
But-
Notwithstanding the difficulties, the conviction remains safe.
Yes.
Certainly, my lord. But here, what I would be, first of all, saying to your lordships is that if, let us say, your lordships are not with me on this issue, then there is another effective way to compensate for that breach, my lord. Because if we agree that there is a breach of section 10.3, then, my lord, you must reflect that breach by compensation.
But you're talking about a breach. Aren't we supposed to be focusing upon a material breach? And if we hold that there was a breach,
Yes.
don't we have to go on to decide whether it was material? And can we only, surely we can only decide whether it's material by listening to, from your point of view, the worst bits of the tape?
Yes, my lord. But I am at the stage where I'm telling to your lordships that if you agree with me, there was a right under section 10.3. The fact of being denied that right and it is breached, there is already a case for your lordship to allow some form of compensation in the sentence at this stage without going any
Sorry,
further.
compensation in the sentence.
Reduction of sentence.
Reduction.
Oh, that's what you want. You don't want money.
No, of course. No, my lord.
I'm sorry, I misunderstood.
But I mean,
You've got two stages.
Right.
Ideally, you'd like the conviction to be quashed, which failing, you'd like the sentence to be reduced.
Precisely, my lord.
well, I mean, a lot of the problem has arisen, obviously, maybe not due to your fault or your client's, but certainly not due to the court's fault, because of the delay since 2004. What sort of, I mean, supposing this matter had come straight up to the board after 2004, we would have been dealing with it as an ordinary appeal, and we would come to the conclusion, rightly or wrongly, that the court below had refused. And would you then be suggesting that there should be some compensation if it had just for that breach?
Maybe not at that time, my lord.
No. Well, how can you be in any better position because you failed to appeal to the board or been unable to appeal?
But, my lord, I believe that it is only if we recognize the breach, it is only fair that that breach is given some sanction.
No, but that's inconsistent with the concession that if it had come up as an ordinary appeal, we wouldn't have been required to think of the points you're now mentioning. I don't see how you're better off as a result of 12 years delay.
I got it wrong. If it had come in 2005, after 2005, before your lordship, and the breach was there, yes, obviously, I would still be saying to your lordship that that breach requires to be reflected in the form of a reduction in sentence. I'm sorry, my lord,
I see. Well, I mean, every constitutional breach has to have some compensation of some sort.
Well, I think you would say that where an unfairness in the trial is demonstrated, even if the Court of Appeal, the appellate court, concludes that notwithstanding the unfairness, the conviction is safe, the court is required to address the question whether, given the unfairness, that should be reflected in a reduction of the sentence.
Yes, my lord.
I mean, that's settled law.
It's certainly what you're saying. Certainly what you're saying, and I understand it. But is there authority anywhere for reflecting unfairnesses in the trial procedure in a reduction in sentence?
Not in the trial procedure, is it?
It's the Ilahi Bockus case.
Eli Bockus, yes, by the board.
It's tab 15.
Yes, my lord.
There was unreasonable delay, and in a judgment delivered by Lord Brown, the board decided to reduce, by reference to the delay, the sentence from 4 years to 3.5.
Precisely. Paragraph 23, my lord, of the page 1315.
That's unreasonable delay on the part of the Court of Criminal Appeal in having heard the case and then taking, was it 17, 19 months to deliver a fairly short judgment?
Yes, my lord.
Well, there's also authority in this jurisdiction to the same effect. I've presided over a court of criminal appeal which has done just that in the past. So it is, we accept the proposition.
The delay can be reflected in an adjustment in sentence. There's no difficulty.
But you have to put it on...
Procedural unfairness in the course of a trial, or for that matter here, in providing documents for the purposes of appeal, is not necessarily quite the same.
I think there is a judgment of Lord Bingham to the effect that where fairness has been demonstrated, unfairness has been demonstrated, it's necessary for the appellate court to address the question whether that should be reflected in a reduction of sentence.
Would that be the case of Randall, my lord?
I can't remember.
What are you saying?
Randall?
Randall.
That's society.
We've got Randall.
It's also consistent, I suppose, with the general approach which is taken under the Human Rights Convention by the European Court of Human Rights, where you have, for example, a failure to provide a prisoner with courses to enable them to achieve an early release. Even if they wouldn't have achieved an early release, nonetheless, the frustration involved has been held to justify that some sort of monetary compensation. But
not a reduction in sentence.
Not a reduction in sentence. That's maybe a different matter. Yeah, that is.
My lord, just for probably, if it is the case of which I was referring to, the case where Lord Bingham, which Lord Kerr was referring to, I'll give you the citation, probably that 2002 Criminal Appeal Report 267.
2 Criminal Appeal Report 267.
Is that Randall you're talking about?
Randall and R, 2002.
Yes, thank you very much.
Just give me that citation again, please.
2002 Criminal Appeal Report at 267.
How's Randall spelled?
Randall.
D-A-double-L.
Lords or in, yes, it is.
Yes.
D-E-double-L?
D-A-double-L.
D-A-double-L.
And you say it's House of Lords, yes?
Yeah.
Yes, I believe so, yes.
If it's the case I'm thinking of.
Yes.
Do you think it's the judgment of Lord Bingham's? Because this is...
I think it is the leading judgment is by Lord Bingham in this matter, my lord.
A different point.
And it seems to be on a different point.
Yeah. It's not that... I don't think it's Randall, but it may be. That's the well-known Randall is actually 2003, so
Right.
you may be thinking of another one.
Right. Well, let's see if...
Well, let's use our resources behind us to see if we can come up with it. In any event, your argument is that if you can demonstrate an unfairness in the trial, but it doesn't mean that the conviction is unsafe, the court has to at least address the question whether or not that should be reflected in a reduction of sentence.
The more so here in this case, my lord, the refusal to make available the audio recording led to a ground not being able to be argued at all or even considered.
Yes.
So that is, I believe, makes matters worse.
Well, except that all this proceeds on the basis that we are not going to express any view about anything else. We are surely, I know you don't suggest this as your case or primary case, but we are surely going to consider whether we should listen to the recording, and if we do listen to it, we're going to consider whether it shows any injustice, and we will probably decide whether or not to listen to it by reference to the same criterion. Have you shown any risk of injustice, you having listened to it and being able to?
I believe, my lords, and I believe it is, I have in my written case, my lord, identified at page, as from page 1113.
Is it paragraph 62 onwards?
Yes, my lord.
In the table?
Yes, in the table. But, my lord, for the table, if we were to listen to the tape, I would here say to your lordship that I've already noted my comment next to it on the tone. I wouldn't ask your lordship to go through them and you together, but there are four specific instances which I would like to take your lordships to, if your lordships were prepared to listen to the tape, and they are to be found at page 67, paragraph 67.
Let's just look at that. 67 is?
Paragraph 67, the manner the judge addresses the defense case.
Yes.
Then three other specific matters at page 1117. That is the first paragraph, which starts with "in those circumstances," the top of the page, my lord.
Sorry,
Just part of paragraph 68.
Yes, my lord.
In italics.
Yes.
Oh, I see.
So it is not part of it, my lord. That's page 404. That's page 414.
So where's it? What is 1117?
Paragraph numbers.
It's part of 68 then, my lord.
Yeah. In those circumstances to suggest.
Yes, my lord.
Thank you.
Well, this is just explaining why an identification parade would have been useless, isn't it? It's colourful.
Well, there's more than that, my lord. There's more than that when...
Why is it page 1117? The reference in the margin is page 414. Have I misunderstood?
That is the volume 1, my lord.
I see. Right.
1117 is probably the electronic number of your skeleton.
Of the respondents.
Yes, I see. Right. Thank you. All right.
I'm not sure that Mr. Lee's evidence, in fact, related to your clients.
No, it is not.
We'll forget that.
Well, I'm not sure it is a point to forget because you're concerned with Thupsy. But where are the other two references?
The other two would be page 4 to the next paragraph.
Yes.
What is the axe to grind?
Yeah.
That's the one.
But I mean, one can deal with this in terms of that one. Thupsy was the witness against your clients.
Yes.
And the judge here is pouring cold. What is he? He's.
Well,
I mean, isn't he being a bit? This is capable of being read as. I see. No, I see the point you're making. Right. That's the third one.
Yeah.
What's the next one?
Then the next one would be the next paragraph, my lord.
Remember I told you.
Remember I told you, yes?
Right?
More
Well, that isn't-
emphasis
that
on the unsatisfactory and not unworthy or unreliable.
Why is listening to the tape going to help with that? If you're right that it's a misdirection, it's there on the printed page.
My lord, the tone is important.
Is it?
The way he stops and he, like in the staccato style,
Okay.
to bring home what is.
But that's, I mean, that fourth comment is rather favourable to your clients, isn't it? He's basically saying, if you were looking around for anything to corroborate the witness against your client, you won't find anything.
But, my lord, it is the use of the word not unworthy, unreliable. That is a matter for the jury to see whether it was unworthy or unreliable.
It's the not, is it?
Yes, the not which is important.
Okay.
Well, isn't he saying you've already disregarded the unworthy or unreliable evidence? You only need corroboration if there's some evidence which could be credible but which is unsatisfactory. And he says there's none. I mean, that's how I read it, but it may be that it's not very clear.
Is Thupsey the witness who we know implicated your clients by saying they were there, but is he also the witness whose account of his history was that he'd been got at by the defendants?
Correct, my lord.
Persuaded to say something different in the
Yes, my lord.
magistrate's court?
Right.
And, yes, I see. So the real issue was whether that was true or not, or might be true or not. No, was true. Was true. Yeah.
Changed his story
changed his
repeatedly.
story,
He had offers of immunity, and there was a question about when they were withdrawn.
It is also, my lord,
Offers of
important.
immunity certainly from the Crown, but before that, according to him, lent on
Bullying, yeah.
by your clients
Parents and brothers
and the family, exactly, and as a result, gave a false account initially. That was his evidence, wasn't it?
Yes.
So the question in the case was effectively, was that true? Is that right?
That's correct, my lord.
Yeah.
And this is where this is why I've asked your lordships also to go to paragraph 67 to listen to that 9 minutes portion, because this is how the judge addresses the defense on that issue.
Right.
Well, I'm a little concerned about the rest of your written case on this, in this area. Do I take it then that paragraph 62, where you set out in a table various points as being positive to the prosecution and downright derogatory to the defence, you don't seek to get anything more from the tone or
Yes,
from the tape than appears on the written?
Yes, my lord.
Right. So we needn't listen to those specific areas. Right. So the only area where you say the tape might be material is what? 67, but do you also say all the other three areas we should?
My lord, I would say even for that bit which doesn't concern my client, as Lord Wilson rightly pointed out, but it will crop up for later on for appellant in the third case.
Yeah.
Because it's material to him.
It's 67 and the 3 paragraphs on the facing page
Yes, my lord.
you've just identified.
Yes.
Right.
Well, now, that's your application, is it, then?
Yes, my lord.
What other submissions do you have, just so we know where we are?
I believe once we are done with that, then that would be probably more or less
Yes.
done.
Right, well, we ought to probably hear what Mr. Boulel says on this subject, amongst others, before reaching a decision on this particular aspect of your submissions. So I think we should just hear Mr. Boulel on that one point.
Yes. And on the conflict.
I don't suppose there's anything your juniors wish to add on.
No, my lord. No, my lord, except, as I said, for number 3, maybe, if need be,
Yes.
my friend would respond to the...
Well, Mr. Uzo, we're delighted to see you, but have you anything to add?
My lords, just very briefly, not addressing your lordships on the issue the content of the tape itself. First of all, I endorse on behalf of the appellants in the second and third appeals, the submissions made by my learned friend for the appellant in the first appeal.
This is Mr. Hirstenbockers, I'm sorry, yes.
Yes, for the...
I was intending to call on Mr. Ramburns Jr., but I certainly should call on you too. Let us just clear. Mr. Uza, there's nothing you want to add?
No, insofar as the first appellant is concerned,
yes. Right, let's hear what Mr. Hirstenbockers says then. Thank you very much indeed.
Grateful, my lords. Yes, first of all, I fully endorse the submissions of my learned friend made on behalf of the appellant in the first appeal, for the appellants in the second and third appeals.
Yes.
I shall just very briefly outline to your lordships a couple of additional points arising out specifically of the respondent's written case. So if I may take your lordships to the appeal proceedings, page 1151.
Are you in the respondent's case now, Mr.
Yes.
Could you possibly do it by paragraph number?
Yes. Paragraph 18.
Thank you very much.
Yeah.
Paragraph 18.
18, yes.
Right.
Yes. Which reads, Section 10(3) of the Constitution is to be read together with the provisions enacted by Parliament to provide for the recording of evidence before the Mauritian courts, namely Sections 23, 24, and 177 of the Courts Act, as well as Section 18 of the Criminal Appeal Act. The effect of these legal provisions is that an appellant is entitled to a transcript of the record, which transcript constitutes the official court record. My lords, it is therefore the respondent's position in respect of Section 10(3) that the section ought to be read together with certain statutory provisions. The respondent seems to suggest that the effect of these statutory provisions is that the appellant would only be entitled to a transcript of the record. My lords, it is submitted that the constitutional right under Section 10(3) cannot be interpreted in light of these statutory provisions, as has been pointed out by my Lord Lord Mans. This is because the Constitution is, in fact, the supreme law of the country. In fact, these statutory provisions are to be interpreted in light of the constitutional provisions and not the other way around.
Yes.
My lords, furthermore, it is my submission that the section cannot be given such a narrow interpretation, as doing so would undermine the very essence of the right enshrined under Section 10(3), which in effect gives the accused person the right to be given any, as highlighted by my Lord Lord Wilson, any which is to be interpreted largely, that is, encompasses the digital recording. Moving on to a second point arising out of the respondent's case, my lords. A couple of paragraphs down, paragraph 29, still in the respondent's case. It is suggested by the respondents that it is unclear how far the case of Asadullah is authority for the proposition that a tape recording should always be made available to an appellant. My lords, if we therefore go to the case of Asadullah, that is at tab 7 of the bundle of authorities, page 12, 26 for sounds of those. No. Paragraph 18, page 12, 26, paragraph 18.
It's one of yours.
Strong call.
12.
Which reads,
Okay.
in the light of Mr. Scooby's much more detailed and extensive complaints, we formed the view during the course of his submission and in the way in which he had put up on some of the complaints that we should call for and listen to the tape of the summing up. We have done this, and having done so, it has assisted us.
Mr. Hirstenbockers, I'm lagging behind. What page are you reading from?
I'm sorry, my lord. This is 1226, tab 7 of the bundle of authorities.
Yes, thank you.
Paragraph 18, my lord.
Thank you. Yes.
And I continue. We have done this, and having done so, it has assisted us better to evaluate the points being made. My lords, we find, therefore, that the court's response to a complaint of an appellant in respect of the nature and tone of a summing up is to call for the tape and listen to it, to enable the court to better assess the complaint being made. And the court has acted on its own initiative in that case, my lords. The appellant's case remains that the recording forms part of the court record, and the case of Asadullah was referred to as support for the proposition that where a complaint is made on behalf of an appellant in respect of a tone used by a judge in the course of a trial, without even having made a motion, the court took it upon itself, in the interest of justice, no doubt, to hear the tape. In our case, my lords, despite a request to be made for this to be made available, and despite inviting the court to listen to it themselves, they refuse even to consider listening to it. And this brings me to a side point. If I may take your lordships to page 515 of volume 2, the last page of the judgment, the paragraph before last, starting with consequently. Consequently, we refuse even to consider hearing the tape.
Well, you need to read that, don't you, with what goes before it?
Yes.
Because, as it says, consequently, the reason is given beforehand.
Yes.
And the reason that they say is that they've not been provided with any sort of basis for thinking that the tape will be any help.
Yes, and that was on reliance on the authorities of Wood and Nelson.
Well,
and my lords, it is my humble submission in respect of that issue that in both cases, Wood and Nelson, no audio recording was available, which is why in those cases the court called for an evidential basis to be placed before them.
Yep.
My lords, moving on to the next issue is still on the respondent's written case at paragraph 31. No evidence about an incendiary tone of voice used by the judge. Such evidence could have been produced if there was any merit in the submission. My lords, the point here is that the respondent seeks evidence which could only have been available if the tape was disclosed and listened to, the more so that there was fresh counsel appearing in the case.
Well, Lord Hughes pointed out that you could have buttressed your case with a bit more than assertion if you'd had a statement from the original counsel. But
yes.
You say that his ground of appeal is there, and anyway, now we're of course in a different position now. But
and specifically that he has since distanced himself from the case. He had withdrawn from the case altogether. So the evidence which was so that was not readily available to the appellant, but the recording itself was in the custody of the court, was available for all intents and purposes, my lords. Therefore, my lords, in respect of that point, to suggest that the appellant ought to have adduced evidence in support of its complaint when the motion for disclosure of that evidence was objected to by the respondents and refused by the court is contradictory. Moving on to another issue altogether, moving on from the issue of disclosure now to the consequences of the non-disclosure. Of course, I endorse the submissions made by my learned friend that in respect of the redress in the sentence. But first and foremost, as pointed out, the fallback position would be the reduction in the sentence. But the first position is that the appellant was in effect, all three appellants were in effect, challenging their convictions before the Court of Criminal Appeal. Now, has there been a fair hearing before the Court of Criminal Appeal? The answer to that, in my humble submission, is in the negative, my lords, because he has been deprived of his constitutional rights Now, if he has been deprived of his constitutional rights, can that finding that the conviction is safe by the Court of Criminal Appeal then be said to be final and in accordance with the rights of the appellants? And that is the point in respect of that, my lords. And I would invite your lordships to now look at paragraph 34 of the respondent's case.
What page is that, please?
1155, my lord.
Thank you.
In the event that the Judicial Committee finds that the Court of Criminal Appeal erred in its decision of 27th October 2004, or ought to have exercised its discretion otherwise by allowing disclosure of the digital recording and listening to it, it is the case for the respondent that this would amount to a wrong exercise of a discretion, a procedural irregularity which can be cured by the appeal process. It does not amount to a breach of the appellant's constitutional rights. In effect, my lords, both the appellants and the respondents were agreeable that the non-disclosure would amount to an irregularity. The appellant's case is that the breach caused by the non-disclosure would amount to a breach of fundamental constitutional rights.
How far does that go? Because, I mean, you say that the fundamental breach here is failure to give a fair hearing, but that can be corrected on appeal, can't it? That's the point that's being made here. And that's the normal course. The fact that it's taken a very large number of years in the present case isn't the court system's fault.
Precisely, my lord.
Isn't the court's fault.
Well, it is. I'm sorry, my lord.
The fact that it has taken, or will have taken, if you succeed in showing that there has been some unfairness, a very large number of years to establish this, is not down to the court.
No,
all that's happened, will have happened, is that there will have been an appeal which will have put things right, which happens very often in the legal.
Lord. Yes, but then it is my humble submission that we have to look at it in context. This motion was made 14 years ago, prior to the appeal, and in one particular context, so that, in effect, the appellant could have put forward his appeal in its entirety before the Court of Criminal Appeal. So it is by no means the fault of the court in respect of the delay, but we must, it is my humble submission that we should not lose sight of the fact that this motion was made in one particular context. So,
well, I think your argument is that there was a breach of his constitutional right to a fair trial. If it proves the case
yes,
that the proviso can be exercised or can be invoked
yes,
in this case, that does not extinguish the breach of the constitutional right. The breach of the constitutional right remains. It may well be that the unfairness in the trial can be overtaken by the decision of the board that the conviction is nevertheless not unsafe, but the breach of the constitutional right remains. So it's not right, you say, for the respondent to say that it doesn't amount to a breach of the appellant's constitutional rights. It does amount to such a breach, but if the proviso comes into operation, then notwithstanding the existence of the breach of the constitutional rights, the conviction is deemed to be unsafe.
Precisely, my lord. Yes, but then, since the issue of proviso has been raised, there is one more issue. The Court of Criminal Appeal, in its final judgment, found that there had been a material irregularity in respect of a doc identification, and then proceeded to apply the proviso to decide that it has not led to a substantial miscarriage of justice. How then, my noble lordships, if we are in the position that, again, the proviso can be applied, what
the proviso is being applied to? It's water under the bridge that the proviso was applied at first instance. What we're concerned with is some potential error by the Court of Appeal in dealing with your appeal. So how does the proviso come in?
it would have been the cumulative effect of...
We don't apply the proviso to
Yes.
Court of Appeal decisions. We decide whether, for ourselves, if the Court of Appeals fail to deal with it properly, what the position would be.
Perhaps I have...
Should have been.
Yes, I'll rephrase, my lord. Perhaps if the Court of Criminal Appeal had the benefit of listening to the tape and come to the conclusion, which we shall never know.
Yes. Well, you're going to presumably endorse Mr. Ramburn's submission that we should listen to certain parts of the tape, in which case we will be in the same position as the Court of Appeal.
In that respect, yes, my lord. Yes.
We still have to hear
Yes, and I will...
the Attorney General as to whether that's an appropriate
on that issue,
course.
yes. Yes.
Sorry, the Director. Apologise.
And just a couple of final points. Paragraph 37 of the respondent's case. The respondent contends that the court's decision not to grant disclosure of the digital recording, if found to be incorrect, is a defect in the trial process. I'll pose here, of course, it is a defect in the appeal process, which can now be rectified on appeal. The concluding paragraph is that not all irregularities of trial amount to a breach of the right of a fair hearing. And the respondent relies on the authority of Forbes and Attorney General of Trinidad and Tobago as authority in support of that proposition. If I may then take your lordship to the authority of Forbes.
Yes, 24.
Which is at tab 23, my lords. Page 1355. Paragraph 12. But if the accused does not know the reasons for his conviction, he cannot show them to be erroneous. He may thus be deprived of a fair and proper appeal process. This is not necessarily the case, but if it is, then it is impossible for the Court of Appeal to be satisfied that the conviction is safe, and it ought to be quashed. Similarly, my lords, it is submitted that in the present case, given that the appellant was denied the opportunity to show that his conviction was erroneous before the Court of Criminal Appeal, he was thus deprived of a fair and proper hearing before that forum. It is humbly submitted, my lords, that in the circumstances, the Court of Criminal Appeal could not have been satisfied that the conviction was safe, and therefore it is not a mere procedural irregularity, as submitted by the respondent, but a breach of the appellant's fundamental rights.
Is there perhaps this difference? Forbes is the case, isn't it, where the magistrate convicted the defendants without saying why?
In effect, yes.
Gave no reasons at all, and never did so subsequently either.
Yes.
So there really wasn't anything the court could do.
Yes.
If there has been which we've to decide, but if there has been in this case an infringement of the appellant's right to have a copy of the tape for the purposes of mounting an appeal, that can be cured because you've now got it.
Yes, and
is that a difference or not?
Yes, that is a point noted in respect of that. That is a difference, my lord. But then again, that brings me to the delay. If the appeal had been made before the board 15 years ago, the board would have been in a position, certainly, to send the matter back to the Court of Criminal Appeal for the appeal to be decided in its entirety, since the Court of Criminal Appeal, in effect, had all of the proceedings of the court below.
But if there were other points which we've already considered and which you've been refused permission to appeal in respect of, there is one point left. The argument that you would have gained something by looking at, in the entirety, at other points which are separate points and don't impact on this doesn't seem to me to work. Either they are linked with this point and have a cumulative effect, or they're not. The grant of permission to appeal on one and the refusal on other indicates that they're separate points and they're not interlinked.
Yes, but in effect, most of the grounds, the other grounds of appeal, were in effect challenging these summing up, be it in directions or otherwise, so that the tape would really have
You mistake it, I think, from the orders we've already made.
Yes.
That we did not see a significant interlinking. We regarded them as discrete points. Otherwise, it would have made no sense to allow you to argue one point,
right,
and to refuse you permission on the others.
Yes, yes. Then, my lords, just to come back to an earlier point raised by my Lord, Lord Hughes, that the ground of appeal in respect of Keramuth is to be found, my Lord, at page 515, which...
Probably not 515.
No, probably not on 515. At 462, I'm sorry.
Thank you very much. 462.
Yes. Which in effect challenges Thupsey's evidence, but also Leating's, the directions of the judge in respect of both witnesses. That is a paragraph 20, ground 25, my lord. Lost.
Yes.
Yes.
Same point as the...
Yeah, it's additional.
Sorry, I haven't got this point. 462 is...
462 is the grounds of appeal in respect of the of appellant Keramuth.
So that's the equivalent of Mr. Ramchand's ground 25.
Oh, it is.
Yes, my lord, in addition...
Yes, I'm with you, yes.
Leating as well, to witness Leating.
Right.
Quite.
And which paragraph are you relying on?
25.
25. Yes, inflammatory tone, so.
Yes.
Right. So you take the same course as Mr. Ramburn. We should now invite the director to
yes, my lord,
make his submissions on the question whether we should listen to the
yes.
recording in order to enable Mr. Ramburn to complete his submissions and you yourself to follow
yes,
with it.
So, yes, unless I can be of any further yes. At this stage. Thank you, my lord.
You yourself have a junior who I should technically, I think, call on, Mr. Mira Sahib. Miss Mira Sahib. Thank you very much indeed. Yes, now, Director, what do you say? I think we just focus on the one question, whether we should listen to the recording in respect to the four areas.
Yes.
Do you want to deal with the Constitution or not?
Well, I think in order to enable Mr. Ramburn to complete his submissions, this is part of his case, we should just hear you on this area at the moment and make up our minds on this area. You will have, obviously, the opportunity to reply on everything else.
Right.
The answer to we've dealt with the questions of the summing up, in particular to the areas pointed out by Mr. Ramburn in the statement of case, in our statement of case at paragraph 67 to 73.
I rather had the impression, Director, that you didn't oppose hearing the tape, rather that you felt that if necessary we should hear the tape because it would make good the points that you make about the lack of inflammatory conduct, or lack of inflammatory tone.
Essentially, what we felt about the question of the tape is that it's not that the tape cannot be made available. It can be made under the discretionary power of the court under the Criminal Appeal Act, but there must be some evidential foundation. Someone cannot just merely rely on a mere ground of appeal to convince the court that there are matters for them to listen. We felt that in this particular case, this evidence was lacking. The foundation that should have been laid for the tape to be disclosed was simply lacking in that case. And in that sense, we subscribe to the reasoning of the court on this particular issue.
Perhaps there is...
There's 2 points. One is whether it should be disclosed. The other is whether the court should be burdened with listening to it.
Yes.
Perhaps we are in slight danger of becoming confused because, as my lord pointed out a moment ago, there are 2 ways in which this case can be looked at. The submission is that there's a right on their part to have the tape, but they have had it, so we are in a situation where they are in a position, whether as a matter of right or on any other basis, to make submissions about the content of the tape. And what we were really asking you at this stage was to focus on the question whether they have shown a ground on which we should listen to it, the fact being that they have it, on whatever basis they have it.
Can I come to Section 10.3? Is that what your lordship want me to add? The right for them to have access to the tape.
Well, I wasn't proposing to invite you to make all your submissions, but it may be we should reconsider that. And in fact, it's quite difficult for you, I can see, to not to do so. Perhaps we should withdraw and just discuss it, do you think?
Yeah. By all means, yes.
Yes, okay.
Yeah, we'll withdraw and just discuss how we proceed, because it may be simpler and more helpful to you if we just hear everything. Yes, Director, the simplest thing will be to hear you on everything you wish to say at this stage. We shall then have to make up our mind after having heard any reply as to whether we listen to the passages.
Thank you, my lord. I just want to just pick up on this. What on the question of the tape is that we have disclosed the tape.
Yes, but you say not under obligation.
Yes. We felt that there was no inflammatory tone, and from the basis of what we've heard, there's nothing which would encourage your lordship, other than from the transcript, to say that there is anything more as regards to the question of the inflammatory tone.
Nothing above the transcript. There's nothing to be gained.
Yes.
Would be your case.
Yes.
Yes.
Oh, there were two avenues were canvassed before the Court of Criminal Appeal. First was the question of Section 10, subsection 3, and the second one was the discretionary power of the court. Now, Section 10, subsection 3 reads, that an accused person shall, if he so requires, and on payment of the appropriate fee, be given within reasonable time after judgment a copy of any record of proceedings made by or on behalf of the appellant. Yes. The question is here is the emphasis is on any. I would say that the emphasis should be on any record. And we have to understand what record means in the circumstances, first from the context, from the from the history of that section and what was the intent of the legislator. I shall start with the intent in the sense that what Section 10.3 goes about to achieve is to ensure that an appellant would have a true, fair, and accurate picture of the court process. And in that sense, we should not make any sort of confusion as to what is the process to safeguard that substantive right and the procedure. The tape recording is used just like shorthand notes was being used to secure the transcript of proceedings. This is, in my humble submission, why Section 10, subsection 3 must be looked at.
I can understand the argument that shorthand notes, you transcribe them, that's like for like. Why, if you have a higher form of recording, do you downgrade it to a pure type? If the fairness of the trial can depend upon the higher form of experience, why should that not be made available to a potential appellant? I mean, life improves, in other words, and we're not in an originalist frame of mind in this jurisdiction.
Whilst I agree that the Section 10, subsection 3 must not suffer from any...
I mean, in this court, it would be a yet higher form of experience available to a potential appellant because we're being videoed.
Yes.
Well, it's a simple question, isn't it? Does the recording constitute a record of the proceedings?
The transcript of the recording?
No.
Yes.
Does the recording, the actual recording of the proceedings, does it constitute a record of the proceedings?
Yes, absolutely.
Well, under Section 10, subsection 3, any person who has been tried for a criminal offence is entitled, on the payment of a fee, to have a record of the proceedings.
A copy of any record, which, I mean, that's why you get a transcript of the writing, and why don't you get a copy of the tape?
Yeah.
Yes. But as I say, I mean, we have, as technology is permeating throughout the judicial system, we have to be able to draw a line somewhere. The transcript
what is the problem? Assuming, firstly, that an appropriate fee has to be paid, so there's no burden on the court system, and secondly, that it doesn't follow that a litigant has the right to vex every court of appeal with a requirement to listen to the whole of the transcript. That can't be required. A court has a discretion how to conduct its proceedings. What's the problem?
I think it's, we have to be wary of the floodgate situation, that there must be a judicious way for the administration of justice. And this is...
I'm sorry, but there's a more fundamental and an interior question to be asked here. If it constitutes a record of the proceedings, Section 10, subsection 3, gives the person the right to have a copy of it. So if you accept, and I think you're right to accept, that the recording of the proceedings is a record, then how can he be denied access to it on the payment of a fee?
He's not being denied as long as he gets the whole transcript of the whole process.
So basically you say that record doesn't mean record, your Lord's using it, it doesn't mean the recording. What it means is a rather more formalistic concept. It means some sort of official transcript that is produced from whatever means. I mean, the paradox is we had a case not long ago from Mauritius where I'm afraid there was a long delay in the delivery of the judgment, and the explanation given as to why that was not a problem was that the judge was able to listen to the recording of the proceedings himself. Well, we didn't accept that as a sufficient explanation, but nonetheless, it's when I say a sufficient explanation, as a necessarily an adequate compensation for the delay and the risks that arise from delay. But there is a slight irony there.
I'm sorry, Director, I've plainly, totally misunderstood your answer to me, because I had understood you to say that you accepted that a recording of the proceedings constituted any record of the proceedings.
Correct. But I'm making also a distinction as to what an appellant is entitled to.
Are you perhaps saying that whilst the tape is, of course, a record of the proceedings, what Section 10.3 is aimed at is providing the defendant, the accused person, with the kind of record which enables him to challenge his conviction if necessary? And that, I think you are saying, is a written transcript rather than the tape. Why isn't it? I mean, I can quite see that any court of appeal is almost certain to say that it simply isn't prepared to act on a tape without a transcript. But the problem is, why isn't it both?
So the question is that what is the right that is safeguarded under subsection 10 and subsection 3? Technology is moving fast, but doesn't mean that we have to draw a line somewhere as to if we say anything goes into what an appellant is entitled. What the record is for the purpose of safeguard by the court is one thing, but what an appellant is entitled to, this is the issue here is why the very purpose for which the Court of Criminal Appeal interpreted Section 10 subsection 3 in context of the provisions of the Courts Act, which have been with us since 1945, and the provision of the Code of the Criminal Appeal Act, which came in 1954. The reason,
I mean, as has been pointed out, that's reversing into the question in the wrong way. It's the other way around, isn't it? The Constitution is the document which prevails, which we have to construe in the light of modern conditions. It's quite apparent that the old the acts haven't been completely updated, and insofar as they have been updated, they do acknowledge precisely the point that my Lord was putting you, namely in section 177.3 on page 1321.
Yes.
The Courts Act specifically says, notwithstanding the old procedure about taking down in writing the oral evidence, etc., the evidence and proceedings may be recorded by tape or other technological means, and the judge. So that's a record there by tape, quite clearly. If you do read them together, it's entirely consistent with a modern reading of Section 10.3.
What was mandatory prior to under Section 23? And we must read Section 23 of the Courts Act, if I may ask.
Well, we know what Section
23
says.
It's the minutes of proceedings.
It's the minutes.
Yes, but the minutes of proceedings and the notes of evidence must be taken as provided by Section 177.
Yeah.
Well, together with the notes of evidence,
Yes.
that's presumably a reference to Section 177.1 and 2, isn't it?
Yes.
Well, now, they are now substituted by Section 177.3, because you don't have taking down notes of evidence anymore. You have a tape recording. So if you read back into Section 23, these minutes, together with the tape recording, shall be preserved as records of the court,
Yes.
which doesn't help you.
May I refer Your Lordship to tab 25 of the case of Polimon? Polimon and the Queen.
Yes.
Well, this was a case for leave to appeal to the Privy Council. At the time the Criminal Appeal Act was enacted, it was felt the Section 18 was drafted with the term shall, implying that there was a mandatory need to take down shorthand notes. May I refer Your Lordship to the second paragraph from the bottom?
It is quite clear.
It is quite clear from the above that the applicant could not complain that he had been deprived of any right guaranteed to him by Section 10, subsection 3, unless he showed that he had been unable to obtain a copy of any record of the proceedings made by or on behalf of the courts. To support that claim, learned counsel submitted that the proceedings had to be recorded in the manner provided by Section 17 of the Criminal Appeal Ordinance.
18, isn't it?
Yes.
Yes. Which is the reference to the shorthand note, and the complaint in this case was that there hadn't been a shorthand note. Is that right?
Yes, for the...
And if there wasn't one, it couldn't be provided with a copy of it.
Yes.
Yes.
Again, it seems to be a bit inconsistent with Section 177 of the Courts Act, or at least as amended by Section 177(3).
In any event, I see this was decided in 1980, presumably before there was any question of recording of the proceedings.
Anyway, what's the point we get from it?
If we perhaps turn the page, yeah. I'll spare Your Lordship from reading this whole paragraph. We find that, and this is what I place my reliance upon, where it seems fourth paragraph from the top, it seems to us that learned counsel is making a confusion between the substantive right conferred on the applicant by Section 10, subsection 3 of the Constitutions, and the procedure by which this right is safeguarded. The substantive right is to have a copy of the record. The right, to say the least, as much safeguarded when the judge keeps a complete and accurate record as when a shorthand writer produces an inaccurate record. In the present case, an accurate copy of the record was made available to the applicant, and no question of any infringement of his right under Section 10, subsection 3. So the substantive right is met by, at the time, the transcript of the shorthand notes, and now...
In that case, it was met by the judge's note. But how does it help in the present case? Because in the present case, there is we're calling it a tape, it's probably convenient, it's a digital recording. But in the present case, there is a tape.
Yes.
It's not a question of the appellant complaining that there isn't one. He's saying there is, and I'm entitled to have it.
No, my point is that it is not obtainable, disclosed as of right under Section 10.3. The tape can be obtained pursuant to the discretionary powers under the Court of Criminal Appeal Act, where it serves the interests of justice.
But
I'm saying it does not come under Section...
unequivocal. He is entitled to any record. So the essential issue is the digital recording, does it come within the definition of any record? And if it does, the appellant say that's an end of the matter. On the payment of the fee, you're entitled to have it. You can't cut down the ambit of any record by reference to legislation which purports to circumscribe the breadth of the constitutional provision.
My position is that we must not read more into what is intended under Section 10, subsection 3. Once someone gets its transcript, and I say that digital recording or shorthand notes were mere aids towards producing that transcript, which will enable any appellant to have an accurate picture of the court process. Now, if someone makes the further step of challenging the tone of the judge, and where the recording would become relevant, then the next step is for that person to convince the court as to the merits of his what he's advancing, which is in a way, as the court found here, a serious allegation as to the impartiality of the judge, and ask the court to exercise its discretion to be given a copy of the digital recording.
Right. Well, I think we have that submission. That's clear. Basis. That's what you say.
Yeah.
And you better address us, I suppose, on the alternative hypotheses. Where are we if there's a right? Where are we if you're right?
We've argued that if there is a right to this digital recording, we say that there is absolutely there was nothing which would encourage the court or which would enable the court to exercise its discretion in favor of disclosing the tape.
Oh, well, wait a minute. That's going round in circles. If there's a right to it, then the court didn't have a discretion.
We must move from the disclosure. I think we have your submission on the disclosure point, but there is, and I think Mr. Ramburn accepted, in fact, both appellants accepted, that there are two separate questions. One is the tape disclosed? The second is, if the appellants have the tape, does the court have a discretion not to be required to listen to it? Is it entitled to require the appellant to come up with cogent reasons to persuade it that there is a problem which requires it to listen?
Absolutely, my lord. If the tape is disclosed, then there is the next hurdle.
Yes.
It is obviously the appellant would be in a much better position having had access to the tape and having been able to identify the passages which they would constitute or regard as being inflammatory. It would be for the appellant to convince the court as to the merits of their submission.
But why can't Mr. Buckery get up on the 19th October 2004 and say, my lords, notices of appeal signed by Mrs. Jiwa, the attorney, were served on the 7th December 2000. The appeals have not yet been heard. The counsel who appeared at trial are no longer instructed. Maybe they're no longer available after 4 years.
Yes.
I am now in the difficult position of preparing to present an appeal for these three appellants. I notice in both notices of appeal, paragraph 25, the allegation of an inflammatory tone.
Yes.
I have a duty to my clients when the appeal comes on to present all their arguments as best as I can. I cannot present paragraph 25 unless I hear the tape. I was not there. In those circumstances, my lords, if I need to persuade you to exercise a discretion, I humbly ask you to do so. What would have been wrong about that?
Nothing, my lord. But let me, the threshold also should not be low. It should be a low threshold. But first, we are at the stage of appeal. At the stage of trial, there was absolutely no complaint, and the presiding judge invited counsel, who is, by the way, experienced counsel, to whether he had any issue. Shall we stop for a moment? May I proceed, my lord?
Yes, please do. Yeah.
Yes. Counsel was invited whether to, after the summing up, whether they had any issue concerning the whole summing up.
Can you just show us that?
Page 444, my lord. 444. Volume 1, page 444.
Right, yes. Yes, any issue or point of law.
There was an invitation whether he was to give further directions.
Was that given in the presence of the jury? It rather looks as if it was.
Must have been.
Yes.
Because of the next sentence.
Yeah.
Yes.
Well, it can sometimes be difficult for counsel to make comments adverse to the judge or effectively critical of the judge, but I take your point.
And I must also say that with due respect to counsel who appeared, even in the, at the Court of Appeal, Your Lordship pointed out earlier that they were themselves reluctant on the question of inflammatory tone, and the case was shifted to one of being biased. And
can you document that too?
Yes.
We've got a page reference to that.
Yes. It's volume 2, my lord.
Yes. It said against
490.
Page 490.
it said against you what do you expect, because they didn't have the material. They weren't they were deprived of it. So it's not a very powerful point, is it?
For what it's worth,
Yes.
it's the third line of the second paragraph of the submission.
Yes. Not making a frontal attack. Right. Well, carry on.
And it is on the basis of this that I would submit that it was not, the court was not being unreasonable by seeking from counsel further particulars as to what they meant when they put forward the question of inflammatory tone. May I refer Your Lordship to the issue, how the court dealt with that at tab 1.
Well, I think we are.
Yeah.
We've had it referred to us, but by all means, quickly.
Very, very quickly, it's a short. Yeah, 1173. In the tab 1, 1173.
Yes, the point is that they had the transcript and they couldn't show any passage in the transcript which they, were identifying as being the occasion when inflammatory remarks were made.
Yes.
Yes.
Well, in a sense, it's been overtaken by events.
Yes.
Because we now have identified for us, it would seem a bit artificial for us to try and put ourselves in the position of the Court of Appeal, which of course didn't have the transcript and didn't have the submissions we now have. So at some point you'll move on to deal with the actual case now made.
If you advance an allegation that the judge had used inflammatory tone in a case of that nature, which can be sensitive case of having had so many persons who died as a result of that incident, inflammatory in that context.
The mere fact you've had the transcript, you're not counsel at the trial.
Yes.
Your clients can, if they remember this, simply say, well, it was clearly loaded against me, but they can't be expected to identify which words. So I think this is all a bit unreal.
It is not unreasonable to ask that counsel who appeared, I mean, there's nothing which suggests that he was not available,
yes,
but to elaborate on an affidavit to explain, or if there is an agreement between counsel of the two parties, if it is in the interest of justice that the judge had gone beyond his limits of impartiality and had used inflammatory tone, which left the jury with no choice other than to convict. So the threshold is that high. Then it is my humble submission, if I may say so, that there should have been something more than merely rely on a mere ground of appeal. And this is
Your point is there should have been an affidavit from the counsel who appeared. The appellants themselves might not be expected to know the detail, but if the counsel who appeared had seen fit to advance this ground of appeal with a high threshold, then they ought to be able to define what it was that let them do that. I think that's your point, yes.
But all this only arises, really, if there was no right.
Yes.
Recording. I mean, if there was a right, then they should have been in a position which they are in now.
Yes.
If there's no right, then I suppose on one view we are caused or required to judge whether the Court of Appeal acted appropriately, even though we now have further submissions. But it's not an entirely happy exercise. But anyway, we've got your submission. You say if there's no right, then they didn't do enough.
Well, I would say even if there was a right and there had been given, there was nothing which substantiated.
If there's a right, we have to go on and look at the way they're putting it now, and they're relying on essentially 4 points, aren't they? They've identified them. And you have to persuade us that you have to address the question whether the 4 points are enough to cause us to do what they further submit, namely listen to the transcript.
But the first issue, my lord, is that the summing up must be looked at
as a whole.
As a whole, we cannot just merely rely on mere passages and to argue that the summing up is tainted as regards to its fairness. The passages which were referred to, I'll just I must say initially 3 passages were earmarked by the appellants. The first passage is at page 391 of volume 1.
right?
Yeah, the first passage regarding criticism which were made against at page 391, starting with ladies and gentlemen.
It's just the 9 minutes. Where have you got 391 from then?
Not in the...
No, it looks...
If you look at the case for the appellant, Mr. Director, you'll see and get to paragraph 67. That we're told now, there may have been reference to other passages in the past.
Yes, yes.
By all means, tell us about that. But at the moment, what we're being asked to look at is paragraph 67, and within 68 on the next page, 3 particular paragraphs. We've got page references from the summing up for the 3 other paragraphs, 414, 429 and 431. We haven't, I think, got a page reference for the beginning of the 9 minutes.
But I think we can take it isn't 391 since it occurred after 1 hour 36 minutes, and 391 is about
Right.
12 pages into the summing up.
Right.
The 9 minutes refer to the 14 points made by... Is this what your lordship...
No, we don't know at the moment what the 9 minutes, what pages the 9 minutes refer to, but it must be pretty
May I have
late in
your-
the summing up.
Page 423.
Page 423, my lord.
423, thank you.
Page 423 on to 4 to something else, is it?
Yes. Well, I mean, if perhaps we have to go and look at this, how do we reach 4 to 8? It is in that context, the judge was dealing
Sorry, where are you now?
423 to 428.
3 to 4 to 8.
Thank you very much.
Yes, he dealt with here extensively with the testimony of the main witness for the prosecution, which was witness Tupsy.
Well, it's the complaint that is made is that the judge, as it's put against you, systematically dismantled consecutively a number of arguments raised on behalf of the appellant, and it looks, does it, as if it's A to J.
That's 4 to 3.
Or at least, perhaps not A to J. It might be A to, it might just be A to H. But in any event, it's reminding the jury of submissions which Mr. Mohammed had made to them.
Yes.
I think it must go on quite a long way,
To M, perhaps.
perhaps to the end.
And
But, Director, in circumstances in which the submission is you won't collect from reading the transcript
Yes.
the vice of which we complain,
yes,
what is the point of our reading the transcript?
the transcript, my lord, would precisely show that there was nothing untoward in the way the presiding judge directed the jury.
Well, I think what you're saying is that the complaint isn't here about tone of voice. It's that it ticked off the points one by one.
Yes.
And that, you
Precisely.
say, we can get out of the transcript just as well as we can out of the tape. Yes?
The tape would not add more
Well,
than
it
what
might or it
you
might
read
not.
and see on the transcript.
Well, it might or it might not.
Well, we can perhaps see a systematic approach to the evidence in the
Yes.
transcript, but the appellant's claim is in the last sentence. It is submitted that the full impact can only be gauged by hearing the tape.
Yes. And your submission is slightly contrary to the one in your case, paragraph 47 and 8, where you've respectfully express the view that it's fortunate the digital recording is still available, and it's somewhat surprising and contradictory for the appellants now to take the position that it ought not to be heard.
Yes.
Now, I mean, I appreciate you were approaching the case from a rather different angle on one view, but even if it's a fortiori, if it's a matter of right, isn't it? Anyway. You say 67 is not good enough, and there's no reason even for us to listen to it. And I presume you say the same about the 3 points made in paragraph 68 of the written case.
Yes, they were all balanced. The judge did not go beyond what the threshold of fairness. He has put across both sides of the arguments. He adopted a pattern of he gave the testimony, an account of all the evidence, and then he took into account the competing submissions that were made. I don't think there's anything objectionable in the way in which he approached the case for the defense. In fact, he was giving a very fair account of all the factual and evidential issues that had arisen in the case.
Well, we see that. The difficulty is the one that Lord Wilson mentioned, that it is said here, counsel are responsible, and one hopes before the board, that is axiomatic, and they have put in words that we can only fairly resolve this case by listening to the tape.
In the case of the question that arose in the case of Asadullah, which, if I may refer Your Lordship to the passage that was just read at tab 7, paragraph 18.
Yes.
18, my Lord. There were detailed and extensive complaints which enabled the court to form the view that listening to the tape would assist the court to better evaluate the issue.
Basically, you're saying they haven't done enough.
They have not done enough.
Yes.
And the overall summing up was fair and balanced and even-handed. Yes, this is the, if there is any further questions from Your Lordship on the question of the fairness that fair hearing which was raised, I wonder if Your Lordship would not want me to address this, because the appellate process is still ongoing, so any remedy can be cured, any irregularity can be cured at this level. So the question of being deprived of a fair hearing does not arise.
There has been on their case a failure in the Court of Criminal Appeal to comply with a constitutional right, but you say that's either been fully cured or else it's no longer material once it's resolved in the appellate process, and you say that no remedy, certainly not presumably in terms of shortening of sentence, is appropriate.
With due respect, my Lord, whilst the question of sentencing remains essentially one for the court's appreciation, I do not see any any analogy which can be made to to the case of Eli Bocus, which was just referred. The delay there was the responsibility of the court, not that of the
Yes.
the appellants. The question of the delay was something which was not, the delay could not have been made irreversible. It was a delay that happened, and you cannot cure it in a way of speaking. But I fear that here the situation is quite different.
I suppose also that the position ought to be further considered after, if we do hear the tape, in the light of whatever conclusions we reach about it.
Yes.
Right, well, is there anything more that you want to say?
No, my lord.
Well, we'll hear whether, Mr. Ramburn, is there anything you want to say by way of reply?
By way of reply, my lord, I'll just...
Sorry, I didn't call upon, I do apologize,
Sorry.
I'm not doing, this is Keramuth. Thank you for being here and apologies for not calling on you.
Maybe just one quick point.
Yes, please.
The point made by the appeal, which is ground 25, maybe we could say on our side, we have to submit part of the ground appeal, because if we look at ground 25, it challenged the directions, the language, and the tone. When it comes to the directions and the language, that has been fully taken care of on appeal, as we can see from the judgment of the court. And I wanted to refer your lordships to pages 702 to 706.
702.
Of volume 2. That is the Court of Criminal Appeals judgment, where we can see that the directions in relation to witness Tupsy were looked at in full.
Yeah.
Right.
In fact, the court started as from page 696 to look at the evidence of witness Tupsy. Besides that evidence, and from pages 702 to 706, goes into all the grounds of appeal that had been raised in relation to the directions that the judge had given in his summary in relation to that witness. And there were about 10 to 12 grounds. I do not know if I'm going to list them. But the point that I wish to make is that when the appellants make the point that they couldn't argue a ground, in fact, it's only probably part of a ground that they could not put forward.
Yes.
Only the issue as to the term.
Well, that's a very helpful point, and we obviously considered these, or some of them, in the context of an application for permission to appeal here. Exactly. No.
Something else which I may wish to add is it automatic if we reach the conclusion that there has been a breach of Section 10.3? Is it automatic that it means that there is a breach of Section 10.1? On our part, from the respondent's perspective, we feel that for it to do so, there would have had to be other factors, maybe something else or something more, in line with possibly the Strasbourg jurisprudence, saying that it is often the combination of a number of procedural deficiencies which would lead to that conclusion. It doesn't necessarily mean if, assuming your lordship's reached the conclusion that Section 10.3 has been breached, that necessarily the appellant's right to a fair trial will be there. To reach that conclusion, we're going to have to look at those proceedings as a whole.
Yes.
And to see what would have been the impact of that one, I would say, mishap, if we can call it that way, assuming your lordships find that it is a mishap. The point that we make in our case, or we try to make at paragraph 39, is essentially that the subsidiary rights within Article 6 we draw the parallel with the European Convention because our Constitution is inspired from it. And the rights as listed in Article 6, and of course those in our Section 10, are not absolute as such, and that their breach or not depends on questions of degree, on the facts of each particular case, and on the circumstances of a particular defendant. Of course, based on our submission that the right under Section 10(3) was guaranteed by the fact that they had a full transcript. One last point which came to my mind. When it comes to digital recording, maybe we need to make the point for the respondent that in Mauritius, it is not in every court that we have a recording. Before the lower courts, it's still shorthand notes or notes taken by the judge or magistrate. In only some cases, before the intermediate court, that we have, that the proceedings are digitally recorded, so that when we look at Section 1773 and may be tempted to look into it, a provision which has come to take over Sections 23 or 24, maybe it is important to bear in mind that digital recording is not in every
I think that's
case.
inherent in Section 177, because it deals with this as an additional possibility.
What already exists, and the competing interests which are probably at stake in deciding whether to disclose or not. If we look at one authority that we've included in the bundle, which is the Supreme Court of Canada, we've looked at the UK as well and seen that the 2015 rules actually require that you set out good reasons as to why recording should be made available to you.
Yes.
Whilst applying to the registrar.
We don't have a constitutional right, though.
True, but in Mauritius we
one
have...
framed in such clear, non-equivocal terms.
Would any mean every, though, my lords, or does any mean any one of a specified class, or any one of many?
You have to persuade the registrar in England of the need for particular parts of the transcript as well. That's the whole point. That's how appeals are done there.
Whereas you seem to have a general...
You start by framing your grounds, and then you identify the bits of transcript that you say you need in order to argue them.
Which makes the point that it's not a very useful analogy to refer to the rules in England and Wales.
The only point we were trying to make was that we do not have rules yet to sort of deal with this aspect back in Mauritius.
Yes, but the rules would have to conform to Section 10, subsection 3.
And the 1954 criminal appeal rules probably would have applied, where again an application to the registrar. But, just one last word maybe about the competing interests at stake. I know that was not what the court took into consideration when they gave their judgment. But when we looked at tab 20, we sort of put in the policy for access to records in Canada. The only point I would wish to make is that it does set out at paragraph 2 the kind of interests that are at stake in any request for any record. On the one hand, the benefit of open courts, and on the other, privacy and security of individuals, the proper administration of justice, resources. Only trying to make the point here, my lords, that it's not as clear-cut.
But I mean, that's court records generally, and that includes a whole welter of things apart from a recording of proceedings in court.
Yes.
That includes the whole file and everything that's filed and no doubt evidence that's not used and so on.
And that extends to the public and the media as well as the parties to the proceedings. I'm not sure if it's a very good analogy.
Right, well...
That is it, really.
That's very, very helpful there. Thank you very much indeed. And on that basis, we do come to Mr. Ramban, yes.
My Lord, only 2 points I would wish to just clarify. First of all, when the director referred to the remarks of Mr. Mohammed SC at page 444, on behalf of appellants number 1 and 2, you will probably, no doubt, have noticed that the other counsel appearing for the other accused were not asked any their evaluation of the summing up.
Well, they are asked, actually. and if you've got the sort of observation which can properly be made at that stage, you must get up but I understand the point that some are difficult to make.
Yes. But my lord, if I understand correctly from the respondent's case, is that at the end of the day, Section 10.3 is a mere technicality then. So, which brings me to the second aspect, is if you have a breach of the Section 10.3, does it necessarily breach Section 10.1? In the circumstances of this case, I say yes, it has, because the appellants were not able to put fully their case. I'm not going to come back again. And it's not a mere technicality. And I say so then on the authority of the case of R against Perrin, probably, the right pronunciation, 1286 to 1293, tab 13, my lord. And I'm referring to page 1289, more specifically. That is in paragraph 24, which starts at 1288. And then this, yes, yep. We add that if the court is driven to the conclusion that the defendant has not had a fair trial when the matter is looked at in the round, the natural conclusion will be that the verdict is unsafe because our system of criminal justice is dependent upon the fundamental principle of the provision of a fair trial. To allow an appeal in such circumstances, even though the evidence for the prosecution may have been exceedingly strong, is not to allow an appeal on a technicality, but to allow it upon a fundamental principle which underlines our criminal justice system.
Yeah, that's where you've held that the trial was unfair, Mr. Ramburn, which begs the question.
Yeah. Right.
But that is all, my lord. For
Right. Yes. Mr. Hurstenbockers.
No, thank you, my lords. Very much.
Well, we will withdraw for a moment just to see where we are and come back. The board's grateful for the submissions heard to this point. We consider that in order to conclude the matter, we should hear the passages which have been identified, I think helpfully on a piece of blue paper to Ms. Gard-Zulaiti, who will operate the machines, and we assume that any points will have been made very largely already, but if there's anything more that either council wishes to submit after we've heard the passages, that will no doubt be open to them to do so. We'll adjourn until 2 o'clock and hear the passages then.
thank you, my lord.